Honorable Chair, fellow participants. First of all, allow me to greet you all and express how honored I am for having this opportunity to participate, at least online, at the third Entan conference. Honorable Professor Đurić, the first author of our paper, unfortunately is unable to attend the conference due to previously accepted obligations, so the duty of short presentation of paper key points, which is the pleasure at the same time, belong to me. Also, I am looking forward to getting valuable comments and suggestions to this presentation and our topic that will be, together with the comments we got from our reviewers, significant contribution to the final version of our paper that will find place, hopefully, in the collection of papers. Our topic, as all of NPR agents in the implementation of linguistic rights are comparative and surveillance perspective. I want to apologize for not carrying the PowerPoint presentation at this point. The great John Locke once said that many disputes among people arise because different things are called by the same name and the same things are named by the different names. In order to avoid it here, and bearing in mind that from this point of view, the key point is and should be the institutional design and the powers of NTR agents, it is necessary to give two prior introductory remarks. The first one is that the topic of the paper are the powers of minority institutions and not the functional non-territorial autonomy. The second one, and in my opinion even more important, the introductory remark is about clearly specifying what is meant by public powers in administrative law, especially considering their meaning in the former Yugoslavia. Namely, in the former Yugoslavia, that notion used to imply the powers of non-state entities to act in authoritative manner, i.e. to perform administrative activities, and since the basis for such an act and such an activity cannot be law, public powers are actually considered as a special legally transferred powers to non-state entities, which allow them to carry out their activities in an authoritative manner. According to some classifications, public powers may consist of regulation of certain relations of vital interest through the bylaws that are the so-called regulatory powers. Then, in resolving specific situations by adopting individual legal acts, as well as other public powers, for example, in issuance of public document. However, since the transfer or delegation of public powers is so closely linked to the importance that the activities those entities have the normal way of life in the particular community, some theorists brought to the table the question of their legal nature of those public powers. Or to say it different, are those public powers truly delegated with the full and unbound discretion of the legislator, or they be seen as inherent when it comes to the specific types of non-state bodies? It seems that NTR agents, which are in Serbia national councils of national minorities, unlike any other non-state bodies, very actualized and even confirms theoretical distinction. However, the great content of public powers of those NPR arrangements can vary widely, from autonomous and final authoritative decision making, especially in individual matters, and the adoption of individual administrative acts, over the participation in public institutions and services management and decision making, including the process of bylaws adoption to the exercise of consultative functions. Bearing in mind that language could be seen and is often seen as a constitutive element that defines a nation in an ethnic sense, it is not surprising that the NTA arrangements are interested in the possibility of exercising linguistic rights in certain areas of social life, but in the different ways and the different schools. They are conducting exercising public powers in the exercise of linguistic rights, and thus vary from the establishment of the institutions to the participation in decision-making in certain issues in the field of culture, education, and information, public information. And this participation in decision-making, for example, in the form of substitute or prior consent, needs to be distinguished from a simple consultation. Respect for this distinction in comparative law could be seen in the powers, for example, of civic plan, who negotiate the government, inter alia, on the issues concerning the same language schools, where the term negotiation is not reduced only on the duty to consult the summit government. This distinction is also noticeable in the powers of national councils of national minorities in Serbia to propose programs. Besides this, the paper with the special focus on official use of language bear in mind that using the language in front of administrative authorities may be, and it is a key indicator of minority language legal status. The official use of language, primarily due to its official nature, there lies an increased degree of authority of NPR arrangements in the exercising of linguistic rights, especially when it comes to the language standardization. In that sense, our paper points out the difference between a right to a language, seen as a collective right, and the right to the language, seen as an individual right, with an interesting statement that although there are different solutions present in comparative law, the Serbian constitution even recognizes constitutional right to a language seen as a collective right. Namely, its article, I think it's 79, stipulates per area that persons belonging to the national minorities shall have a right in areas where they make a significant relation proceedings there, and with this before this organization, but with delegated powers, bodies of autonomous provinces, and local self-government units, as well as in some areas, a right to traditional local names, street settlements, and topographic names, also in their language, which determine the content of the official use of particular minority language. Also, when it comes to the official language status recognition, unfortunately or not, but there are no strictly norms or legal standards in this regard, which shift this issue into the domain of politics, although some linguists strongly and rightfully oppose it. NPR arrangements therefore do not have powers in the field of defining and recognizing separate languages, but they do have certain faults in their standardization. Theoretically speaking, they lack their capacities in official language recognition is by this compensated to certain levels of control over the bodies which are in charge when it comes to the language standardization. And last but not least, among the wide spectrum of public powers and their arrangements regarding the official use of language, light was shed paper on one particular and unusual power existing in the Serbian legal order. It is about the power of the Article 22 of the law of National Councils of National Minorities, which gives national councils of national minorities a power to determine the traditional names of local self-government units, settlements, and other geographical names in the language of that national minority under the one condition, and that one condition is that the language of national minority is in official use of the relevant local self-government unit or settlement. The uniqueness of this public power is reflected in the high degree of its authority, unlike the vast majority of other powers of national councils of national minorities in the Republic of Serbia. Namely, with this public power, national councils are in position to finally and authoritatively determine the names of settlements and the local self-government units, even without any restrictions or foundations in historical or real needs. On the other hand, the possibility of its implementation is time limited, which can be seen as a counterweight to the degree of its authority. Namely, the transitional provisions of the law stipulate that if the National Council does not determine the traditional names within the 3 months from the day the law entered into force, the traditional names will be determined by the government or body of autonomous government units, national minority organizations, and also experts in language, history, and geography of that particular national minority. Circumstances such as definitive character and its high degree of authority, but also certain time constraints, on the other hand, are particularly theoretically intriguing if we put them in the context of the above-mentioned theoretical dilemma about the legal nature of public powers of NTA arrangements in Republic of Serbia. However, those circumstances led Professor Đurić and me to the conclusion that this particular power is postulated somewhat contradictory in the Serbian legal system. And finally, to sum up, a few general tendencies can be noticed. It seems that in the comparative law, the public powers of the NTA arrangement as the content of the legal framework of their role are most pronounced in the field of implementation of linguistic rights, but in a different ways and to the different extents. Namely, having in mind that the linguistic rights are exercised in the different fields. In comparative law, there is a notable tendency that in the fields of education, culture, and information, public powers have a sort of participatory managerial character, and that they, to some extent, participate in decision-making. On the other hand, it is notable that the comparative legislation remain reluctant to recognize any NTA arrangement's role in of determining name or distinctive elements of the language of the communities represented by such arrangements, and that even in the case of a single authoritative and final determination of traditional names, that such arrangements, as I said, have in Serbia, their exercise is limited by certain legal conditions which are capable to even start the reconsideration of the very legal nature of such powers. Thank you for your attention.
Thank you very much, Vasilij, for your presentation. Now I open the floor for questions.
I am sorry to interrupt you, but I don't hear you.
So I need to come now. Can you hear me now?
Yes.
Okay. So thank you for your presentation. I'm now opening the floor for questions. You mentioned something about a standardization of language. I know that the Vlach Minority Council has been engaged in standardization of the Vlach language. Do you know any other example and how it can go? And on the other hand, this is one set of questions. On the other hand, what Katinka also mentioned that actually many of the competencies depend on actually the status of minority language, and if the minority language is not in the official status in either of the municipalities in Serbia, then actually the scope of activities is very limited. Yeah. And finally, whether you know your Katinka, to what extent, I know that Hungarian National Minority Councils was active in initiating controls and also through litigation tried to actually improve the quality of implementation of minority language rights. Are you familiar with other such cases of other national councils? So these are some of my thoughts, and then I hope that the audience someone else will also contribute with the questions. So thank you.
Okay, unfortunately, I'm not familiar with the cases in practice about initiating the administrative supervision or surveillance of the official use of language you mentioned when it comes to the Hungarian national minorities. And to refer what Honorable Fellow Beretka said, I couldn't agree more with her that the capacities of community itself determine the extent of the exercising of the well-postulated legal framework in Serbia. For example, I talked to a member of Czech national minority a few days ago, and he told me that the official use of Czech language, which is in official use in some settlements, for example, Bela Crkva in Vojvodina, although there are no sufficient number of Czech minority in that settlement, is simply not sufficient because the Czech minority, the members of Czech minority themselves do not know the Czech language. So in that sense, I totally understand and agree with the unpopular and unpleasant situation in which the smaller communities are unfortunately put in Serbia. And can you please repeat what was the first question?
It was about standardization. It's something what actually some research institution or language institutes in some, but interestingly in Serbia, I know this Vlah case and Vlah National Minority Councils which really engaged in the standardization process as one of the main issues on their political or generally agenda. So do you know anything about this and other? I don't know to what extent, for example, Roma Minority Council was engaged in Roma language standardization, and is it also for national minority councils to engage with language standardization? I don't know.
It is beside the black situation you mentioned, which also has a significant political dimension. I'm not familiar with any other cases, but to the best of my knowledge, the role of even Black community, Black National Council, is to be engaged in the process, but to be non-binding advices or opinions in the process of language standardization.
Thank you. Any other question? Ivan, I know.
Yes, thank you very much for this.
Sorry, can you hear this question? Sorry, Ivan, just to check. Can you hear?
Then translate.
Not in the best way.
Okay.
You should press the microphone.
Okay.
Is it okay now?
Closer.
Is it okay now?
Yeah.
Yes, it's
Okay.
better now.
Well, thank you very much for the presentation. I have just one question. I was just wondering, speaking of linguistic rights, because in Macedonia we now have a new institution, a special agency that is entrusted to make sure that the legal documents, the legal obligations are implemented. I was wondering if there is any other legal mechanism in Serbia that would take care of the implementation or enforcement of these legal provisions which you elaborated, stemming from the Constitution and also in the other elements of the legal system.
If I understand well, you are asking me if there is any special agency which is entrusted with the power to control over the official use of language.
It doesn't have to be special. I'm just wondering how and who controls or makes sure that what is being enshrined into the legal system is being actually implemented. Inspectorate, whatever body. Is there any body that takes care of this?
as it is legally postulated, the competencies of administrative supervision or surveillance is under the inspectorates, under the ministry, the relevant ministries in the Republic of Serbia. And I mentioned it earlier, there is one particular and unique public power of national councils that they are entrusted with the power to initiate and suggest the start of that surveillance, if they think that official use is not sufficient or it is neglected.
If I may be perhaps more illustrative, if I believe that my linguistic rights have been violated or I cannot achieve them as enshrined in the legal documents, who do I turn to? Where do I appeal? How is this going to be dealt with?
Sorry, I didn't hear you well.
What to do what a person can do if right to use of language has been violated?
The person can address the National Council, and the National Council can initiate that surveillance, administrative surveillance. Since the official use of language is postulated as a constitutional right, person has the possibility of submitting the constitutional complaint after all other legal remedies are exhausted.
If I may add, and Katinka, I have more like research experience, so there are different ways. One is so there is a right to use of language, and it is considered if a person wants to use own language and has not the possibility to use it in a procedure, that is also violation of the procedural rules. So then in a complaint, both in administrative procedures and court procedures, it can be a reason for complaining, for complaint. In Serbian, it's bitna povreda postupka, so violation of the procedures. So this is in individual case. In a more general, and there has in previous times people also addressed the ombudsperson on a non-litigation issues, and there have been cases before ombudsman a few years ago or in the previous mandate. The ombudsman is dormant a little bit practically today. But on a general scale, there is a possibility of inspectoral control. For Central Serbia, it's Ministry of Public Administration, and in Vojvodina, there is a special secretariat for different administration, education, and national minorities. It's a pretty much conglomerate secretariat where also...
Cultural education.
Sorry?
Cultural education and national.
Yeah, exactly. So there is no, let's say, agency as Macedonia, but there are different, let's say, channel to address the issue both on individual or on more general level. Any other? So when we are about national minority councils, and I would just ask two of you first. But open also for the wider audience, the question which is now slowly coming to Serbia. It has been on the agenda for several years, but now it also appeared in an advisory committee opinion, last one. It's about the issue of centralization of national minority councils, because as you know, there is one national minority council for each minority has only one council, and with 4 minorities which have population so concentrated, it's maybe not so problematic, but especially for dispersed minorities, or for example for minorities living in Belgrade, there has been identified that this centralized concept of minority councils is maybe not optimal. What is your? It's not so language rights, but generally maybe Katinka, you also have your experience. Are there any? Do you think that there is a chance to consider this? So decentralization, let's say, or different conceptualization of minority councils in order to make them closer to the members of the community and somehow to make them. I know that some minority councils have their offices or branches in the local communities, but do you think that there is any prospect of changing this and really institutionalize decentralization of minority councils? So we have time, but so.
I can answer first. Sorry, because of the colleague.
So what do we?
Just to close the microphone.
Okay.
Ivan.
Ivan, have you turned on? Switched off. Okay.
Okay, it's now better. Yeah.
To close your.
When
I did.
No, this one, the left.
the legislation process
It's-
has begun about the law on the NTA. So as far as you know, it was a quite long process. So it has been in 2002 when the Federal Minority Protection Act was adopted. So actually, over 7 years, we were waiting to have only a separate act on NTA. And there were a couple of drafts. And among others, one draft was about decentralization of NTA. And there were some other drafts that to have such concept like we have now about decentralized form. And what is interesting that minorities, bigger one, like Slovaks, Hungarians, or Romanians, were for this decentralized form in order to have the powers in one hand, or to concentrate the powers within one body. See, the smaller minorities, or even the official, some bigger NGOs located in Belgrade, were to have this decentralized form. So this was actually a story from 2007, and this is still actual. Why this other concept was prevailing, the reason is that they really did not know that time whether the new concept of minority councils will lead to any activities, corruption, because if you don't have this strong management and control in one hand or within one body, then you cannot really control what will happen in fields. And I know that there were certain debates both in politics and in science. And because there were certain amendments to the law, actually this question was not raised. And I really don't think so that it will be open soon. But it can work only, I think, for such minorities who are strong enough to take the control over the entire community. Otherwise, it can lead to certain misuse of resources and powers. So this is my personal opinion and what I know from historical.
Any other question or comment? If not, then maybe we can just close the session, the panel. Thank you very much for your great presentations. Thank you for the discussion. And